Good evening and welcome to tonight's Strata Committee training webinar. Thank you so much for your support in this initiative and listening to what we've got to say about our various topics we have this evening. Feel free to use the Q&A function and just a note, this session is being recorded. Who am I? My name is Andrew Tunks. I'm the Learning and Development Director here at NetStrata, and we have quite a lot of information to get through this evening. A little disclaimer before we get underway. This webinar is for informational purposes only and should not be construed as legal advice. The information provided in this webinar is not a substitute for professional legal advice. If you feel your strata scheme require advice on something we talk about tonight, feel free to obviously reach out to your strata manager who can assist you in pointing you in the right direction. Just to begin also, our strata managers do receive regular training. They're all either licensed strata managers or on the pathway to become licensed strata managers, and there's a pile of different courses that we've developed in-house that our managers go through. So basically they study a certificate for Strata Community Management as well as our in-house courses, our industry CPD, etc., etc. We're very proud of the resources that we have for our strata managers and believe they're the best trained in the industry, which leads us to the reasons why we're running Strata Committee training, because we feel that we have something to give to our client schemes, and on the screen there is a pile of different topics that we look to cover during our Strata Committee training webinar. So if you're not familiar with this setup, basically our webinars run for roughly an hour. The recordings are then issued to anybody who has signed up for Strata Committee training. So whether they've actually attended the webinar or not, we'll send a recording out, and feel free to pass that on to any other committee members within your Strata scheme. In the email that we'll send out to you, there'll be a few little pictures like you see on the screen there, and you can click on the links and listen to those pre-recorded webinars from the past. We do conduct these webinars quarterly, the next one obviously coming around the September mark, so look out for the invite for that one. Who are we as NetStrata? We were established in 1996 here in humble Hurstville and Carlton. Our portfolio ranges all across the Sydney Metro, all the way up to Newcastle, all the way down to Wollongong, Kiama, and all the way west to Goulburn, actually. So we're sort of just about everywhere. We've won awards. We're very proud of that, and we're very glad that you're on these webinars, obviously, to get a little education piece from us. So moving on to our topics tonight, Strata Committee training. Tonight is going to be a practical session for committee members, tackling the real-world challenges of CCTV, so CCTV cameras, vehicle enforcement, so generally a typical issue in most strata schemes with people parking in the wrong spots or parking in your allocated parking perhaps, resident behaviour, and staying on the right side of strata law. So the topics we're going to talk about, as I said, CCTV, basically headlining it is surveillance without the drama, illegally parked cars, so what committees can do or can assist their strata managers in doing. We'll talk about managing conflict and difficult residents, talk a little bit about bylaws and bylaw management, etc. And the final topic there for the evening will be Strata Committee Powers, so what you can and cannot do. We'll break down a couple of sections of the legislation and give you some practical examples of what you can and can't do as committee members. So the first topic, CCTV in strata. So generally speaking, an empowering bylaw, which is a bylaw that allows the owner's corporation to add or change common property, is generally required in order to install CCTV cameras on common property. So any additions to common property, so the common areas of the strata scheme, require a special resolution in accordance with Section 108 of the Strata Schemes Management Act. And what a special resolution means, it basically means that 75% or more of the owners using the unit of entitlement, not like ordinary resolution where it's one lot owner equals one vote. In this instance, we use the units of entitlement, must be in favour of the motion. So basically, when you have a general meeting, there are different resolution types. A special resolution is, as I say, where you require 75% or more of the unit of entitlement votes to be in favour of the motion in order to pass the motion. Now, an example is changes to common property. adding, removing, repealing bylaws. Things like just passing a budget or deciding on a quote, etc., are ordinary resolutions, so generally needing a simple majority in favour of the motion. Now, we recommend the following to be included in a CCTV bylaw. So, where an owner's corporation is considering putting cameras throughout the building, or perhaps you bought into a new building and there are security cameras, but there may not be a bylaw covering how the cameras work, who looks at the cameras, etc., we would suggest that you get a bylaw in Quick Smart. Now, effectively, what we suggest to be in that bylaw, so if bylaws are the rules for the building, this particular CCTV bylaw would include the purpose of the bylaw, so that cameras are to be used for security or compliance with the bylaws, locations of the cameras and the privacy safeguards. We'd also recommend there's comments around data access and data retention policy. So how long do you retain the data for? That is a little bit of a grey area out there in the industry, and I've got a bit of case law to talk about during this webinar on that one. Also, the processes for responding to footage requests. Now, as a strata manager, I get various different requests from people. Let's say their push bike got stolen in the common areas, or they want to know who, stole their parcel in the letterbox area, or all sorts of requests we get. Generally speaking, your CCTV bylaw should outline the process that an owner's corporation would ordinarily take in order to allow someone to get footage. So typically we would say if something has been stolen, go via the police and effectively get a police event number. The police would contact our office. We would ask them for certain security information, which I'm going to run through in this webinar, and effectively we would either allow them to record the footage, or we would get the footage recorded and provided to them once a police event number has been provided to us. Also, obligations for signage and notification. So in the state of New South Wales, it is required that where CCTV is installed, that there are signage around the common areas when people enter into the building, so that they do know that they are being recorded when they're walking around the common areas. It also acts as obviously a deterrent to people to do the wrong thing, because they know obviously there are cameras throughout the building. Next up here, what about lot owners? So we get the request from time to time for lot owners who would like to install their own CCTV cameras, and you think, well, why would they want to do that? Potentially, there might be, townhouses or villas where they've got courtyards. The courtyard might, go onto some sort of common area or park or something like that, and they want to put cameras up, obviously to safeguard people entering through the rear of their property. Another example we're seeing a lot of, and there's a little image on the screen on the left-hand side there, is doorbell cameras. So seems like quite a simple thing, a doorbell camera. I've actually got one myself. It's brilliant. Not very expensive. You can put a camera on, connect it to your Wi-Fi, use apps on your mobile phone. If someone hits the doorbell, obviously you can see who's there. No need for a peephole in your door or anything like that. You can obviously view it. But obviously there is an aesthetic issue being in Strata to make sure it's uniform. So typically we would say if a lot owner would like a doorbell like that, again, the best course of action is having it included in a bylaw of the type, not necessarily the brand, but the type, the colour, where it's to be located, etc. And of course, consider things like, the privacy. What is it looking into? If it's just looking into the common areas, or if it's a villa or a townhouse, just looking onto the driveway of the site, it's probably not an issue. But if that doorbell camera sort of, intrudes looking into somebody's property, then potentially it might be an issue. So generally speaking, if a lot owner would like a security camera installed, again, a bylaw would be required because effectively they're adding to common property. So like that image on the wall there, that's obviously going to be stuck on the outside of a wall or a door or something like that. And that door or wall, which is the boundary of the lot, is common property. So it requires the owner's corporation's approval. And again, it would require a special resolution at a general meeting. Now, the camera positioning is important to consider. So making sure it doesn't impede privacy of other residents. Clearly explaining to the owner's corporation, I guess, as to why they want the camera and the locations, etc. Moving on, so back onto sort of common property CCTV footage for a moment. So who can view or request the CCTV? Now, Any person in their right mind can obviously request access to the cameras, but the owners corporation does have discretion to approve or deny the request based on the purpose of the request. Now, as you can imagine, in Strata, everyone has got to live somewhere. You get all sorts of requests for footage. Some people want to look at what their neighbour's doing, or some people have had something stolen, or they want to know who damaged the common property. There's all sorts of reasons. And generally speaking, the owners corporation should have some sort of policy as to, why they would let somebody view that footage. So it's not just a free-for-all that everyone goes logging onto the camera and helps themselves out, that there is a process involved. Generally speaking, that would be coming to ourselves as the Strata managing agents, and we would manage the request. Generally speaking, we would, if something has been stolen or damaged, we would request that the matter be referred to the police. Once we have a police event number, we would then provide the footage to the police. Is generally the best course of action. Next one here, talking about the data for a moment. So strata searches. So a strata search is basically where a lot owner, potentially if they're selling their property, they may allow the potential purchaser to come into the office, or arrange a strata search company to come into the office, read the books and records of the owners corporation, and effectively make a decision whether to buy or sell the property. Now, strata searches, as it says, down below, services potential purchasers, sometimes lot owners, or other people with the consent of a lot owner can search the records of an owners corporation under Section 182 of the Strata Schemes Management Act. Now, here, if somebody is looking for footage and they do a strata search and they want to access footage, effectively, the footage, if it is downloaded and it is on the strata records, it could be viewed. And now, generally speaking, systems aren't that brilliant. CCTV doesn't necessarily save the data directly into the strata records. It would generally have to be provided and obviously saved into the records of the owners corporation. So it's not generally the way that if someone did a strata search, they would get access to the footage, because obviously the records are not at the building. The cameras are at the building, recording to a hard drive, generally on site, or sometimes connected to the cloud. That information doesn't automatically feed into the system. However, if footage is obtained and saved on the records, it could be viewed under a strata search. Now, what if your CCTV is monitored? Now, some larger or commercial or mixed-use strata schemes decide, we've got so many cameras around the common areas, we'll get an external company to monitor for security purposes. So if a third-party provider hosts the footage, access then depends on the owner's corporation's contract over that data. So essentially, that monitoring company would store the data generally on the cloud, accessing the data remotely. So there would be an internet connection at the building, and then they would look at the footages, and obviously where police requests, or a building manager or a strata manager or a strata committee request footage, they would look at that, be able to save that, and obviously pass the information on. Next question we get asked often is, how long must the owners corporation keep the footage for? So generally speaking, most DVR recorders for CCTV that you can purchase these days, you have the option, the bigger the system, obviously the longer the data can be stored for. So effectively, there has been some case law on this. So it's up on the screen there. Basically, there was a case, so there's no legal obligation to retain footage for 7 years, like Strata Records, due to a legal case. And effectively 30 to 60 days in that particular case was deemed to be acceptable. So generally speaking, most DVR recorders will retain the footage for around 30 days. So if you're out there shopping for an owners corporation DVR recorder and a bunch of cameras, that's sort of your ballpark. Generally between 30 and 60 days is ample. If someone hasn't reported an incident within that period, then there's generally no obligation on the owners corporation to do anything further. All right, so what can legally be recorded? The next step here. So under the Surveillance Devices Act 2007, which is a state-based piece of legislation, it prevents audio recordings without consent. So generally the cameras in our common areas are just video. There's no audio to that. It also restricts camera use where there is an expectation of privacy, unless there's a necessity or it's appropriate. So here, what we have to stress is cameras should not be, inside someone's homes, inside common area bathrooms, change rooms, gyms, saunas, pools. And I know for some strata schemes, maybe if there has been damage or there's safety issues for pools, sometimes they can justify that. Again, does it pass the pub test? It is, I guess, a matter for committees to consider privacy and accord, obviously, with the legislation. Under the Commonwealth Privacy Act 1988, where recordings are outsourced to a monitoring company, the handling of the footage must comply with Australian privacy principles. So just bear that one in mind. Now, complying with police requests for CCTV access. So here we have to say, don't be scammed. So we have a practice in our office here at NetStrata that we do request the police event number. We request a reason for the event. What is it that we're looking for on the footages? And we want to know who we're dealing with. So we get in writing the name and the badge number of the officer. And generally, if it's an urgent issue, they'll shoot that through via email very, very promptly. We can get onto the request. So we treat these obviously with utmost importance, but we just have to make sure that it's a genuine request. So written request specifying the time, date, location of the incident. And here, sometimes viewing CCTV can be trying to find a needle in a haystack. They might give you, in the last 7 days, something was stolen. That's a very long time to sit there and look at camera footage for a whole week. So you can fast forward, and some cameras only move on or record on motion. However, obviously, there's a lot of data to get through. So we try and get that as specific as we can. And if we've got to engage security contractors and pay for their time to go out to the building, obviously we want that request to be, pretty bang on so that they're not wasting a whole bunch of time at the building. Next one here, the police requests need to be acted on promptly. As I said, we need to be cautious and refer to a policy or process in the bylaw for the scheme. So we do recommend that the CCTV bylaw does have reference to how you deal with these sorts of things. So before we move on to the second topic for this evening, we'll just summarise the CCTV considerations. So as we've said, we suggest adopting a detailed bylaw, installing with proper authority. So again, if you're installing new CCTV to a building or adding to cameras, camera systems, the proper authority is required. So generally speaking, a special resolution at a general meeting. Respect privacy boundaries, limit footage access. So if you're in a larger building with a building manager, generally speaking, the building manager would manage that. And if there's any recordings, they can help you out there. And also cooperate with law enforcement carefully and clearly signpost the building. So if there is security cameras, there should be signage around there. So I'll just have a little quick look at the Q&A and just see if we've got any questions about that topic that I can just answer on the fly here. Okay, really good question here. Are there any rules around placing fake cameras as deterrents? Now, we get asked this from time to time. I'm not a lawyer and I don't want to sort of impinge on giving legal advice, but my understanding is if you have fake cameras, you could run into trouble where people actually think that there are cameras there and rely on that for safety and then get quite angry when they ask for footage and it doesn't exist because the camera doesn't work. I'm also advised that if you have fake cameras, you should actually have signage up and should have real cameras. So it's probably one that's worthy of getting legal advice specific to your situation. But nonetheless, I believe the answer is get some real cameras. The other thing too is cameras have come a long way. As I said, I have one of those doorbell cameras. They're Wi-Fi related, and effectively, there's a lot of cameras on the market these days that don't require a whole lot of wiring, and the cost of these sorts of devices has come down dramatically since 5 or 10 years ago, where you had to get wiring and conduit all over the place. Nowadays, you can get remote cameras and that sort of thing, which can keep the cost down. Another question here, does this apply to pre-existing cameras? Now, if you have a pre-existing camera system and you have a bylaw in place that there are cameras, you should be covered. If you are wanting to add cameras around the building, I would generally suggest still requiring a special resolution motion at a general meeting to add to the system. But nonetheless, if you've got a bylaw in place, generally speaking, you should be well covered. Just making sure that your bylaw addresses these sorts of items, who's going to look at the footage, etc. If you've got an older bylaw, potentially just consider an update at your next meeting. Yeah. All right, so just moving on to our second topic this evening, and point number 2 here, illegally parked cars, what committees can actually do. So we'll break this down. Generally speaking, it's a common issue in most strata schemes. I was going to say in New South Wales, but probably in the entire world, I'd imagine, people parking in the wrong spot. All right, so to stay compliant and avoid liability, the owners corporation must have enforceable bylaws in place. So generally speaking, 99% of strata schemes have a parking bylaw. Don't park on common property. It's a standard bylaw out there. You might have something a little better than that. Document all steps carefully. So if you've got people parked in the wrong spots, pretty easy these days with just about everybody has a smartphone. So it's pretty easy to take, a video or footage or camera footage rather of a vehicle, a bike, a car, whatever it may be, parked in the wrong spot, and then shoot it through to your manager with the date and time of the incident. So pretty easy to document things these days. Observe all statutory notice periods, which I'll get to in a second. And the applicable legislation that we're going to talk about here is the Strata Schemes Management Act 2015 and the Uncollected Goods Act 1995, which sounds a bit rogue, but I'll explain the reasons why in a moment. But before I move on, we had some really helpful sections in the Strata Schemes Management Regulation 2016, which allowed you to give 7 days notice pretty much once you put a notice on a vehicle and tow it. That section has been repealed. So it's a little bit difficult how we remove vehicles that are remaining on common property. I'm going to walk you through the challenges and I guess the legal avenues for it. But generally, these days, we're relying on the Uncollected Goods Act. And again, some sections of that act that were really helpful have been repealed. So we're relying on a very sort of acute section of the act, which I'll walk you through. Now, firstly, let's talk about the issues that we get in relation to parking. So the first one is obviously owners or residents parking in visitor parking. That they may own one parking space and they have 2 or 3 cars. Their son or daughter's parked in the visitor spot and they're permanently there. And when you have your visitor come over, there's nowhere to park and they're out on the street or they're halfway, down the road. So that's an issue. Incorrect parking, so people crossing the line or potentially parking in the wrong spot. So although your individual parking spot is actually lot property, not common property, 9 times out of 10, the strata manager is asked to step in and help and try and find the culprit and get them to move their car so you can park in your own spot. Typically, I say, if you've got issues with people parking in your spot, I would suggest adopting a bollard bylaw, which dictates what sort of bollards people can put in their car space to keep it uniform and essentially put one in your space. So when you're not there, you can put the bollard up, protect your space so that other people aren't parking there. We'll also talk about unauthorised parking. So people that just park on the driveway, on the front lawn, all over the shop, not in a space. Again, that is still a breach of bylaws. Now, if you're a TV watcher and you watch the news, you may have come across some recent media which was on a current affair. It was actually in a building that we managed where a strata committee went ahead and effectively had wheel clamps put on vehicles. And effectively ended up getting themselves onto a current affair, so a bit of airtime there. So if you punch in Google, recent media wheel clamping, you'll be able to watch what happened there. But effectively, just to hit the high notes here, wheel clamping is not permitted in New South Wales, and here's the kicker, unless consent to clamp is provided. And a current affair did hit on that. So effectively, who in their right mind is going to give you consent to wheel clamp their car? I do not know. I certainly wouldn't, but that is the rules in New South Wales. Not sure about other states. I believe it may be allowed, but typically in New South Wales it can't be. So there's a little bit of media there you can jump on and have a watch. All right, understanding the legal framework. So, Strata Schemes Management Act 2015. In New South Wales, the control and enforcement of parking on strata property is governed by several pieces of legislation. So, under the Strata Act, Owners Corporation has the power and duty to control, manage, and administer the common property in Section 9 of the Act. The Act also allows the Owners Corporation to make and enforce bylaws, which often include restrictions around parking. So Schedule 3 of the regulations and Model Bylaw 1 specifically address the use of common property for vehicle parking and permit the Owners Corporation to regulate parking by way of signage or written authorisation. So note, bylaws are building specific and can be amended via special resolution at a general meeting. So if you've got a very simple bylaw, you might want to look at increasing it or adding other controls in there. But if a new model bylaw comes out by the regulator, doesn't necessarily mean that is passed for your scheme. So the bylaws that you have for your scheme are the bylaws for your scheme, unless your Owners Corporation decide to add, remove or amend any of those bylaws. So under the Strata Schemes Management Act, it outlines the enforcement process of when somebody breaches the bylaws, including the issuance of notices to comply, which we're going to talk about, and imposing penalties. So with relevant procedures in sections 146 and 147. So as I mentioned a moment ago, there's a couple of regulations that have been repealed. 32 to 34 in the regulations were repealed a number of years ago, actually, which allowed us to remove dumped items or dumped vehicles on common property. Now, as I said, we're relying on another piece of legislation, but there's a few more boxes to tick for us to do that. Now, the regulation and legislation that we're relying on these days is the Uncollected Goods Act 1995, and again, state-based. So where a vehicle has been abandoned or left on common property without authorisation and the owner cannot be contacted or refuses to remove it, Uncollected Goods Act provides a statutory process for lawful disposal. So this act categorises goods, including vehicles, based on their estimated value and imposes obligations on the controller of the goods, in this case it'd be the Owners Corporation, as to how such goods must be dealt with depending on that value. So step one in this process is, generally speaking, we'd look for confirmation of the breach. So if you're a active Strata Committee member on the line this evening and you've got photos of residents parking in the wrong spot or people parking on the common areas, you'd obtain evidence, take some photos, send it through to your Strata manager. Now we'd look to check the bylaws to ensure that there is a breach. And obviously record the dates and times of the vehicles and the details. Now, finding the owner can be very difficult. If owners are not aware who the vehicle owner is, sometimes you're lucky and you see the car parked in, for example, unit number 3's garage, and then next week you see it in the common property. You can draw the conclusion that it potentially is their vehicle if it's been parking in their spot. However, there's nowhere in the legislation that requires lot owners or tenants to give their vehicle registration numbers to the Owners Corporation. So the Act governs what information we need to be told. Reg number, unfortunately, is not one of those. For larger buildings with building managers, generally they have like a building detail form and request that information before they, potentially let someone move in and put padding up on the lift and that sort of thing. However, as I said, at law, it's unenforceable to obtain that information. Step number 2, you'd issue a notice or warning. And again, if you know who it is. So if the owner can be identified, Strata Manager generally issues 1 to 2 warning notices. So if the warnings don't yield a positive result, then we move on to what's called a notice to comply. So section 146 of the Act says that the Owners Corporation may, and they use that word may, enforce the bylaws, and a notice to comply is basically a formal prescribed form that we would issue to the offender and allow reasonable time for the vehicle to be removed. Now, if they don't remove it, we can then consider mediation. So we can chat with the occupant if we know who it is and say, look, would you mind attending mediation? We want to talk about the issue. Or we could consider applying for a penalty to be imposed because they haven't moved their vehicle. Generally, point 2 is the direction most owners corporations go for parking breaches. For things like animal complaints or whatnot, maybe they would go to mediation, but parking's pretty simple. If you've got a photo of a vehicle in the wrong spot, you know who it is, it's pretty easy to issue warning notices, etc. And then if they don't comply with that, you can run off to NCAT and seek that there's a monetary penalty issued, which is this step: apply to New South Wales Civil and Administrative Tribunal, or NCAT. So you can seek an order for the vehicle's removal. NCAT may issue enforceable directions, and NCAT can enforce the bylaws. Now, if that doesn't work, apply the Uncollected Goods Act. Now, how this works: if the vehicle is considered abandoned or the owner is unresponsive or unknown, the Uncollected Goods Act may come into effect. So the Owners Corporation, as I said a couple of slides ago, is the controller of the goods under Section 5, Clause 2. Must comply with certain notice and disposal requirements. Let me run you through. And I've got some lovely pictures of cars that I think fit this category. So to apply Section 20, 21 and 22 of the Uncollected Goods Act, for low value goods, so less than $1,000, so I tried to find a nice little bomb on the internet there, require a minimum of 14 days notice. Now, medium value goods, 1,000 to 20,000, requires at least 1 month's notice that you're going to remove the vehicle or the good from common property. Or high value goods, $20,000 or more, nice big Mercedes there, require a minimum of 3 months' notice that you're going to remove the vehicle. Now, how do you give notice? Well, you have to do it in writing. You have to include a description of the vehicle's location. So is it in the visitor parking? Is it in the driveway? Is it on the front lawn? The intention of disposing it needs to be really clear. We will get rid of this vehicle on this date if it is not removed prior. Nice and clear. Affix the notice to the vehicle and display it prominently on the premises, so around the building. So it goes on the vehicle, goes around the building. I would suggest the notice boards, the lifts, front doors. You could even letterbox drop it, slip it under each door. And we do have a template letter that we use for this that covers the legislative requirements. And if we do know who they are, delivered to the last known address of the owner. And I would suggest doing that via registered post so that there's some sort of record there of that. Then if the vehicle is not removed, here comes the fun part. The Owners Corporation may dispose of it. Even funner part, the proceeds from the sale of the goods, if you do sell it, must be held in trust for the owners for a period of 6 months. But generally speaking, you just get the vehicle towed, and you're generally not putting it at Slattery's auctions or something like that. You're generally trying to just move it on, free up the common property. Reasonable costs incurred for the removal, storage or disposal may be deducted from the sale proceeds if you go down that avenue. Now, moving on here, steps to remove the illegally parked vehicle. Step 6, so engage the council or a licensed towing contractor. So typically it would be a licensed towing contractor. It's very rare that the council would respond and come and tow vehicles unless you have some sort of arrangement with them. Some open air parking spaces in community associations or larger stratas may do this. Generally speaking, for the smaller or middle-sized schemes, it would be engaging a private contractor. Generally speaking, private contractor is not going to remove the vehicle unless you can show them evidence that you've put notices around the building for the time period that I've just showed up on the screen, depending on the estimated value of the goods, and that time period has elapsed. Now, final warning here is basically owners corporations must exercise caution to avoid liability. Towing or interfering with a vehicle without first complying with the law may constitute trespass and effectively be illegal. You can't just rock up, tow vehicles and get rid of them. There is a process. It's advisable to maintain a parking register. Again, not legally enforceable, but some people do comply with resident detail form requests, etc., which are quite helpful in this instance. Ensure that bylaws related to parking are up to date, so have a good look at those. Consider introducing or updating the bylaw specifically for parking enforcement if it's an issue at your scheme, including mechanisms such as security patrols, time-limited parking, and the use of warning stickers. And just so that you know, generally speaking, the warning sticker would need to go on generally speaking, it's the right rear passenger window on the side of the vehicle. So not obstruct the driver. It's not on the windscreen, not on their windows, etc., where their mirrors are or whatnot. Because if they get in the car and they get into an accident because you've stickered the daylights out of the car, potentially you're breaching the law. So look out for that one. All right, moving on. Next topic here is managing conflict and difficult residents. Now, typically, if you live in strata, you've come across conflict or difficult residents in some shape or form. Now, we're going to be talking about using notices to comply effectively. So we just briefly talked about Section 146 of the Act. I'm going to unpack that a little bit further for you. In this slide, actually. So typically how it works, and we just talked about parking breaches, so we're going to stick with that as an example. Step number one, right at the top of the tree there, evidence and notification. So typically what we aim to do is get evidence of the bylaw breach. So parking, very simple, photos, date stamp, email to your strata manager, simple, done. Things like noise and party, a little harder, but these days everyone's got a smartphone recording, that sort of thing is not difficult. Got to be careful around the privacy of that, but nonetheless, evidence can be sought. Typically what we would do is notify the resident 1, 2, 3 times that they've breached the bylaws, and then move to what's called a notice to comply. So this is where we would seek the committee's authority to issue a notice to comply, which is issued generally via registered post, and we sign a stat dec that we have issued the notice to the occupant, and we give them a reasonable time to respond. Now, if they do not respond and stop breaching the bylaws, the Owners Corporation had two routes that they can follow. So on the left of the screen, you've got mediation. So typically you would go to mediation if there's something worth talking about, to be truthful. So if it's, let's say, a pet breach, or if somebody's breached the bylaw by installing a $20,000 pergola and it's an eyesore, you would generally want to go to mediation. And the reason is you would generally want to go to mediation because if it doesn't work, you would be seeking an order for them to remove that pergola or whatever it may be. And then again, if they don't follow that, you can seek a larger monetary penalty for a breach of an order of up to $5,500. If you pick the route on the right-hand side, after serving a notice to comply, if, again, we'll stick with a simple parking breach, let's say they continue to park on common property, the Owners Corporation can seek a monetary penalty up to $1,100 for the first offence, and if they repeat that breach, up to $2,200 if the breach is within 12 months. So there's two options there. So generally speaking, you would go mediation and an order if it's a bit more complex. If it's pretty straightforward, like parking in the wrong spot and you've got evidence and you know who the vehicle belongs to, you'd go breach to a notice to comply and get them a monetary penalty for not following the rules. Now, to avoid the he said, she said arguments, generally evidence is best collected using photos, sent through us, again, pretty easy. If you, an email with this is, from 11 o'clock last night, here's the Toyota Corolla parked in the visitor spot, a photo of it parked in a resident's garage, generally, as I said before, provides a bit of a link as to who owns the vehicle. Written statements also help, and sound recordings if it's, a noise breach. The other thing is you may or may not be aware of our NetStrata app. You can actually report bylaw complaints or bylaw breaches using the app. So if you want to pull out your phone and quickly scan the QR code and download the app if you haven't already, or there is also a link on our website that you can do that as well. Really easy to report a breach here. You just go top right to add, effectively bylaw complaint, hit that, and then you fill it out, and you can add photos or evidence, video evidence, etc. And that will go straight through to your strata manager, and then we can obviously pick up the phone, have a chat with you, or if it's pretty straightforward, we can obviously just deal with it directly with the offender, either by phoning them or issuing them a bylaw breach, etc. So we do try and take the personal approach and try and reach out to them to make sure they're aware. Some owners or occupants are not aware that they've breached the bylaws, but obviously if it's quite obvious and they're repeat offenders, then we follow the legal process. All right, important notes on the reporting of bylaw breaches. So evidence of breaches are not passed on to complainants, so we keep them private. However, you have to remember that it would form a record of the Owners Corporation. So any email sent to a strata manager is basically a record of the owner's corporation. So it should be there for a record inspection. So if someone searches the records, and we've had, as I said before, where you're selling your lot, you might have somebody to do a strata search, but also lot owners can request to read the books and records. So if you've got neighbourly disputes, etc., just bear in mind that, emails, etc., can be viewed, and photos and all that sort of thing. They can also be called upon if we have to take the matter further to NCAT or even a court or something like that, and that evidence, can be used for those sorts of things. Evidence of a breach will be recorded within the records. As I said, it's required at law. So moving on here to what's fair. So if the breach affects others, generally speaking, I think it is generally worth pursuing. Consider the costs of pursuing bylaw breaches. What I mean by that is if you have to go all the way to mediation, generally it's either costing the strata committee or strata managers time. And if we're there, obviously there's generally speaking additional time for that. Or if we've got to lodge NCAT proceedings or take the matter even further, there can be costs involved in that. So ask your strata manager, they'll outline what the costings would be if you're to pursue bylaw breaches. And also just remember it sets a precedent. So if you let things go, that sets a precedent. If you pursue things, generally that sets a precedent also. Now, looking if the Strata Committee receive a complaint and believe that it is unreasonable to pursue it, so there might be a party or some sort of thing, and you don't necessarily think it was an issue. It might be you generally get a complaint New Year's Eve, 9 o'clock at night, someone's having a party, and most of you think, oh well, it's New Year's Eve, just let them have a party. Might not be an issue, might be their very, very first offence or something like that. Here's a copy of the legislation that we rely on, and it's on the screen. Now, I've got a word, three words actually, highlighted in gold, and I'll just read it to you. So, an owner's corporation for a strata scheme may give a notice in a form approved by the secretary. Secretary with the big S means fair trading, means a regulator, to the owner or occupier of a lot in the scheme, requiring the owner or occupier to comply with specified bylaw if the owner's corporation in bold here, is satisfied that the owner or occupier has contravened that bylaw. So what am I talking about? If you receive a potentially vexatious complaint, it is the owner's corporation's right to pursue the bylaw, and also their right to use discretion and say, well, look, it's not worth pursuing. For example, we don't want to pursue it. And I've got some options to talk about in a second of how you can direct that complaint. But nonetheless, the word may. It doesn't say must, it says may. And again, you've got to be satisfied that they contravene the bylaws. So sometimes one person's view of noise is very different to another. And generally speaking, that's why disputes happen and you end up at mediation, because your opinions differ. Nonetheless, we can direct you accordingly. So I'm going to talk through complaints that you do wish to proceed, but before I do that, I'm going to say a couple of things about complaints that the Strata Committee do not wish to pursue. So let's say if you've got a vexatious complainant and they've issued a bunch of bylaw breach requests or notifications about a neighbour or someone in the building, you can direct that owner, if the owner's corporation don't want to deal with the matter, that owner or occupant has every right to run off to NCAT themselves. The legislation says tribunal. What they mean is NCAT, New South Wales Civil and Administrative Tribunal, and they can make an application that the matter is reviewed. So general disputes between neighbours, they can access mediation services independently. So nothing prevents an interested person, is what the law says, from applying to NCAT to seek a resolution to a dispute. Adequately document the reasons for non-pursuit though. So as a committee, cover your tail end, put in writing, I guess, the reasons why, the Owners Corporation or Strata Committee do not want to pursue the breach, and obviously generally help that complainant seek advice from Office of Fair Trading or NCAT. So Section 232 is a section of the strata legislation that we rely upon to settle disputes or rectify complaints. Now, it has these words: orders relating to complaints and disputes. The tribunal may, again, the word may, on application by an interested person, original owner or building manager, make an order to settle a complaint or dispute. And it goes on with a bunch of examples, etc. But the key here is on application by an interested person. So it can be the original owner, building manager, or a lot owner, whoever is an interested person. There's definitions in the Act around that. Moving on, so complaints that the Strata Committee do wish to pursue. Now, here is if we're going to run off to mediation or NCAT or seek that they get a monetary penalty, we need to document the matter, follow the legal process, collect and save evidence. And if we run off to NCAT, the evidence has to be filed in a particular way. It's actually quite prescriptive how we need to file the evidence. We can't just dump 3,000 photos on a USB and say, good luck, member at NCAT. We've got to spell it out to them, give them evidence. They see a lot of matters every day. Need to make it nice and clear if you want a result. Remain fair and objective. So part of your role as a Strata Committee member and my colleague's role is to be independent, fair and objective. So, try and look at the complaint in the complainant's eyes, and obviously try and also look at the potential or alleged offender's eyes and what it is that they're being accused of as well. Consider the facts, consider the cost of pursuing disputes. So management costs, like I say, running off to court and NCAT and spending, half a day or a day in mediation costs money. Applications cost money, potential legal fees if you're appointing lawyers to represent you, etc. That all costs money. So generally speaking, the best thing to do is hold a committee meeting, ask your strata manager these questions. What is the cost of pursuing this? Sometimes committees want to be involved. Sometimes they want to stay out of it and let the strata manager run off to mediation, etc., being that independent person, etc. Now, the next bit here, when to engage the OFT. So Office of Fair Trading, again, I've got my little tree there on the left-hand side. If you're going down the left-hand side and you're going to mediation and applying for an order, etc., you go to fair trading first. For general disputes, you can go there for bylaw disputes, and most matters that you want an order. So if you're seeking an order for somebody to do something, typically you need to mediate first. I'll give you a few examples of an order. An order might be to, pay your levies. An order might be to, comply with a bylaw, so remove your vehicle from common property. An order might be that you remove your purple blinds because the bylaws say you have white blinds. An order might be a whole multitude of different things, and the legislation notes, 20 or 30 odd reasons why you might seek an order, but nonetheless, you generally need to mediate first. If you're going to NCAT, generally it's after mediation, or as I said, on that right-hand branch there, if you're just got a really open and shut case, real simple one, and you want to seek a monetary penalty for a breach of a notice to comply, again, you can run off to NCAT to seek a penalty. So mediation versus litigation, so balancing the two approaches here. So while mediation is often a mandated first step in New South Wales strata disputes, it's not always sufficient, especially in complex or high stakes situations. So owners corporations should assess the nature of the dispute, potential costs and desired outcomes when deciding between mediation and litigation. So in short, consider the time it takes, the costs, the dispute type, and obviously, if needed, seek initial advice on what your options are depending on the dispute. Now, I'll just have a quick look if there's any questions so far in relation to bylaws, just in our chat there. A good question here. How long does NCAT usually take to respond? Typically, if you're applying for NCAT, if you're applying for a monetary penalty, it can be anywhere between sort of 2 to 3 months. I'm seeing that these days. If you're seeking an order, there's another order type, an order for access. So let's say the unit above you is leaking water into your unit. You can apply for what's called an interim order. I believe they're looked at within 7 days. But a normal order for other reasons is typically, it can take 2 to 3 months. So it can take quite a bit of time to get in front of a member. Generally, there'll be like a directions hearing where they gather evidence and tell you when to sort of serve your evidence by. And then after that, you'll have a hearing date. Typically these days, a lot of the hearings happen on the phone. Since COVID, a lot of mediation and NCAT hearings happen on the phone, or sometimes they're in the city, or they could be in the Hurstville office or Parramatta or wherever the case may be. Looking at a couple of the others here. Um, Oh, here's a good one. What about breaches related to Airbnb rentals in the building? How to deal with them? Okay, so there's been a little bit of change in the legislation of late. Now, effectively, the Airbnb, you can pass a bylaw to ban Airbnb or short stay occupancy types. Now, the trick here, though, is you can't ban it if it's somebody's primary residence. So, for example, if I live in a two-bedroom unit, I Airbnb my second bedroom. You can't prevent me. However, if I don't live there, you can pass a bylaw that stops those short-term rentals. Now, there is also a whole bunch of other requirements. It's actually not a bad topic for a new webinar. Thank you for that one. But effectively, the Airbnbs are also regulated at a state government level. If you're going to put your property on Airbnb, it needs to be registered. I believe you can only do it for, I think the number at the moment is 180 days a year. So they're really cracking down on that. And again, there is a register generally with the state government on that one. But you would deal with those disputes the same way you deal with a normal bylaw breach. But you've got to have the bylaw to restrict Airbnb first. So you can't obviously pursue them. If you don't have a specific Airbnb bylaw, it's allowed in your building basically for 180 days a year. So look at it that way. Yeah. Another good question here. Who issues orders? NCAT, New South Wales Civil and Administrative Tribunal. So you've got to seek an order via them. If you're going up the chain, I mean, courts issue orders, but strata disputes generally sit at NCAT jurisdiction. Yeah, hope that helps. Okay, I've got a good one here. What if a car parks in the driveway every night, but is not there during the day? You could probably use a bylaw to clarify um, yeah, what you expect in that regard. It might be if it's seen in visitor parking more than 2 or 3 days a week, you could say that it's not a visitor. Yep, but generally, yeah, reach out to your strata manager and talk about that specific circumstance. Uh, all right. Okay, we've got quite a few there. How much? We've got one here. How much does a typical ANCAT application cost with the engagement of lawyers? Typically, the application to the government department is inexpensive. I think it's around the $100 mark. But if you're engaging lawyers, depending on the issue, if they have to provide evidence, you could be in the thousands of dollars. If it's a simple one like a parking one, generally our strata managers can handle that. An application might take an hour or two to prepare. Going to the hearing is the time-consuming part. Generally, sometimes it's 2 to 3 to 4 hours, depending how long NCAT take to hear it. And then obviously any other wrap-up sort of admin work you have to do after it. So typically, if you went to NCAT for an order, you're probably not going to see much change out of $1,500 to $2,000 after application fees, additional fees. If you're engaging lawyers and it's a real serious big event, it might even be, again in the thousands, depending on how many hours they're spending on the matter. So it's probably best to consult with your strata manager. And look, you can bring that cost down if committees get involved and want to go to the hearings as well. But yeah, typically it's just based on time. All right, because time is getting away from us, I will move on to the fourth topic because there's quite a lot to cover under this one. Strata Committee Powers, what you can and can't do. So I'm going to start off by highlighting some legislation here. So Section 36 of the Strata Act outlines the functions of a Strata Committee. So it says a couple of things here. Says the Strata Committee has the functions conferred on it by the Act. Great. Point two, a decision of a Strata Committee is taken to be the decision of the Owners Corporation. So I'll read that again. Decision of a Strata Committee is taken to be the decision of the Owners Corporation. However, in the event of a disagreement between the Owners Corporation and a Strata Committee, so if a committee's made a call, other owners disagree, they can call a meeting and basically override that decision. So the Owners Corporation's decision always overrides that of the Strata Committees. So the following decisions cannot be made by the Strata Committee. Point a decision that is required by or under any act to be made by the Owners Corporation by unanimous res or special res or in a general meeting. Point B, a decision on any matter or type of matter that the owners corporation has determined in a general meeting is to be considered or decided only by the owners corporation in a general meeting. So what that's talking about at your AGM, if the owners corporation say, committee, I don't want you to decide these particular items or spend any more than $1,000, then those matters would have to come back to a general meeting. Now, point 4, an owners corporation may, in a general meeting, continue to exercise all functions or any of the functions conferred on it by the Act or the bylaws, even though a strata committee holds office. So bear that one in mind. So let's unpack it here. So decisions that ordinarily can be made. So I want to give you some practical examples here. Provided restrictions have not been placed on the committee at the preceding annual general meeting. So what I mean by that is the motion to consider restrictions on a committee at the AGM, if the owners corporation have not placed any additional restrictions on you as a committee, these are typically items that you can decide. So things like approving quotes for budgeted works, approving tradespeople for the scheme, assisting with approvals for works pursuant to bylaws for the scheme, pursuit of bylaw breaches, general decisions that you make from time to time, and basic legal matters. So not fighting it out in court for $500,000, just real basic stuff. So costing up to 15 grand for urgent items or up to 3 grand for non-urgent. I'll give you an example of urgent. Let's say you're in a relatively new building with a 2-year defect warranty on non-major defects. Let's say you're at year 1 year and 11 months and there was outstanding defects and you wanted to get legal advice. That would be an urgent matter because obviously your time frame for your warranties are about to expire. And an example of a non-urgent matter up to 3,000 would be, let's say you've heard this webinar tonight and you think, let's go out and get a solicitor to draft us a new parking bylaw. Might cost you $1,000 or $2,000 or something like that. That is a non-urgent item. So it's not critical. So you've got a lower bar that you can comply with there. So note here, where decisions have been made at a general meeting by an owners corporation, these decisions need to be abided by. So you can't make a decision at the AGM and then 3 days later the committee go and do the opposite, right? Because as I said before, the legislation says decisions of the committee are decisions of the owners corporation trump the decisions of the Strata Committee. So unpacking the next little bit here. So decisions that cannot be made by the Strata Committee, which ordinarily would need to be made by the Owners Corp at an annual general meeting or another general meeting. So general meeting means a meeting of all of the owners or where all of the owners can attend. So things like changes or additions to common property. So where you're adding like things like cameras or you might be adding a new planter box at the front or adding furniture or something like that, requires a special resolution at a general meeting. Striking levies, so ordinary levies like your admin and your capital works fund or special levies, again, you don't have the power as Strata Committee members to make that call, has to go back to a general meeting at law. Changes to bylaws, we've talked about it, needs a 75% or more of the units of entitlement, so a special resolution to be passed. Legal matters, again, over 15,000 for urgent, over 3K for non-urgent, would have to go back to a general meeting. Contracts already entered into by the owners corporation. Again, if you've got a 5-year contract with your building manager, the committee can't then turn around and say, sorry, we'll want to throw that in the bin. Well, the owners corporation entered into that contract. That's binding because it's the decision's been made at a general meeting. Again, decisions made by the owners corporation at a general meeting, obviously committees can't change those unless obviously they call a new general meeting and get the owners corporation to decide otherwise. We're going to move on here to a spending limit and quotation section. So section 102 of the Act gives a $30,000 rule, which is the amount prescribed in Regulation 25 of the Strata regulations here. Now it's broken into a number of different sections here. I want to make it a bit easier. I'm not just going to read this one off the screen. I want to break it down nice and simple for you. So effectively what it is any works that are considered to be over $30,000 in value require a second quote, or at least a second quote. The Act talks about also where a large scheme, and a large scheme is where you've got more than 100 lots, so 101 or more lots within the strata scheme, so bigger strata schemes. They also have a restriction where they can't spend any more than 10% of a particular budget item. That would need to come back to a general meeting. So let me break it down for you. So subclause 1 and 2 are sort of together, and I'll highlight that for you. Section 2 sort of is clause 3 and 4 there. Sort of section 3 chunks off talking around what emergencies are, and talks about independent quotes at the end there. So in summary, quotations for work over $30,000. As I said, effectively you need to get a second quote. Large schemes that can't spend any more than 10% of a particular line item. So, for example, if you had a budget in your admin fund of $10,000 for plumbing, let's say you'd already spent $9,500 and you get a quote for $3,000 to replace a pump or something, you would have to go back to a general meeting. So you can't spend any more than 10% over and above a particular line item. However, that can be removed. So a lot of large strata schemes remove that because it's more expensive to hold a general meeting than it is to get the work done. So typically a lot of owners corporations actually remove that rule, and the law allows that to happen. It also talks about this section of the Act, like getting additional quotes, etc., and the 10% rule doesn't apply to emergencies. So if you've got a burst pipe, or you've got a fire in the building and you've got to remediate it, or whatever the case may be, obviously you're not bound by that. And the last little bit clarifies that the quotations have to be independent. So it can't be, Uncle Bob's ABN and then his other ABN, for example, and two quotes are presented as the same entity. Can't be that. It has to be completely separate. All right, so break it down a little bit further. So the key points, as I said, works over 30,000 to be tendered. Examples are cleaning contracts, so larger cleaning contracts. So the annual rate over that amount. The building management contracts, gardening, waterproofing, roof replacements, other building works, applies to all schemes. So it used to only apply to large, now it's non-large. So anything from 2 lots to 1,000 lots, you've got the same rules in place. Where additional quotations cannot be sought, an explanation is to be provided at the next general meeting. So here are potential reasons why a second or third quote may not be possible. So the law says you should get a second quote, but what if it's specialised work? So we've had, works in buildings that we manage a building in Rhodes where it has a thing called a heliostat on the roof, and there's like only one, a handful of companies in the Southern Hemisphere that do that sort of work. It's very difficult to get a second or third quote in a timely manner. It might be something like a sole supplier or proprietary service. So, for example, a lot of new buildings, they come with intercom systems that can only be serviced by a particular contractor, for example. If that's the case, and it's only one contractor, like a particular brand, I won't name the brand, but a particular brand of intercom, there's only one importer in Australia. They almost have the new business market or the new property market, almost stitched up. They get all the business. They're the only ones that bring the materials in. So typically in that, it might not be worthy getting a second or third quote because anyone else has got to buy the equipment off that importer, for example. The time frame might be unachievable. For example, in the case of urgent work. The work might also be in contracts. So I talked about cleaning. It might be in a 5-year cleaning contract. Well, you're not going to go out and get 2 quotes every year if you're in a 5-year contract, for example. And that's, lift works, cleaning, gardening, all that sort of stuff. Part of larger work. So sometimes you're doing a large remedial project and you might get a variation. And it's, you can't actually go and get another, like if you're re-rendering a building and a 20-story building and you've got render on level 18 and it was a variation and it's $50,000 to do, for example, you're not going to go out and get another supplier to come with access equipment and do that because you're in contract with that particular remedial builder, for example. It might be remote or regional locations. We see this in remote areas. I do a lot of industry training. I met somebody who runs a strata business in Coffs Harbour and they said there's only, remedial builders. We only have a handful to choose from and they're all really busy. Sometimes you can't get that second or third quote. There might be existing contracts or warranties in place, or there might be refusal from other contractors, to come and give quotes. So there might be reasons why the strata manager or committee are unable to do that. Next bit here, only applying to large schemes. So we watch the budget. If it's going over 10%, we alert the Strata Committee. The Act doesn't specify that a general meeting would need to be called. However, it's commonly assumed that this is the case. That's that large scheme, 10% of the budget rule. Now, a little bit more on that. Why would we propose a motion to remove that 10% expenditure item? Well, generally there's confusion in the legislation as what you actually need to do. So example, do you need to call a meeting? Do you need committee approval to spend more? Like that plumbing example that I gave you. Do you need to reallocate funds? Allowing the owners to vote on this motion clears up what they want us to do or want the Strata Committee to do, for example. Now, talking about emergency works, so this section about additional quotations, again, it doesn't apply to things like burst or block pipes, storm damage or natural disasters, fire, insurance claim, unexpected electrical or security failures or glass breakage that affects security. Independent quotes, pretty easy, parties that are not connected or related. Now, I just want to talk briefly here about emergency versus non-emergency. So what is considered an emergency? So things like impacts to health or safety, so gas leaks, dangerous structures, risk, significant damage to the property, so it might be burst pipes or flooding, roof leakage, sewerage overflows, and affect essential services. So things like total loss of electricity, gas or water, lift breakdowns, car park access issues, maybe the gate stuck open or closed or something like that. Now, what is not considered an emergency? So things like dripping taps or noisy pipes. So sometimes we get calls on our after hours line, 10, 11 o'clock at night where somebody's got a dripping tap and they want to report it. Well, that's not an emergency. That can wait till the next day. They've got a cracked tile in the common area or something like that, or malfunctioning appliances. Previously, when I managed a large portfolio, I had somebody call me at like 11 o'clock at night on a Saturday and the dishwasher didn't work. Well, what am I going to do about that at 11 o'clock at night on a Saturday? And also, it's lot property. It's not a common property or owner's corporation issue. Routine maintenance is not an emergency. It can be handled the next day. And noise complaints or behaviour issues. So again, it's not uncommon that we get phone calls late at night where parties and things are going on. Generally, we refer it to the police. We don't have the jurisdiction, nor does the Strata Committee, to shut parties down or things like that. So generally, we refer that to the police. One of my last slides here. So emergency versus non-emergency. Who decides? So the decision depends on the context and the urgency, but who decides to engage the emergency contractor, I guess is what I'm trying to get at here. So Strata committees, they can approve emergency works. Strata manager under delegation, so managers like ourselves, we can deal with emergencies. So yeah, if it fits one of the examples I've given, we would obviously call somebody out and get the matter dealt with. Owners, in very limited situations, if an owner sees an issue that's clearly dangerous and urgent, they can obviously authorise emergency trades, but they'll need to prove that it was urgent and may not always be reimbursed. So if they've called out because blocked toilet or blocked drain in their lot, it might be a occupant causation and therefore they might need to pay the bill. Emergency services, so if the issue is life-threatening, again, fire brigade or the council may take control. All right, just going to move on to another little topic before we close up the webinar. I'll just have a look at the Q&A in a moment here. But how the committees make decisions, I want to just talk about this. So decision making can be made via email. It can also be made via committee meetings. So I just want to highlight, both situations here. So typically, when we're asking for decisions to be made via email, they're generally for simple or non-contentious items. So things like approving minor quotes, authorising minor applications, time-sensitive issues, low-risk procedural tasks. So a tip here is it's helpful to ratify key decisions at the next meeting, for transparency reasons to other owners. Things that require a Strata committee meeting might be contentious decisions, items requiring, we've talked a lot tonight about notices to comply, going to NCAT, mediating disputes. Those items you would make the decision at a committee meeting whether the owner's corporation would proceed. So that's where you consider the cost, consider who goes, who's involved. Also anything requiring debate or professional advice. You generally corral that to a Strata committee meeting. Deciding on legal matters. again, which may potentially need to go to a general meeting, given that the dollar threshold there, big picture items, and where procedural fairness matters. And I also want to just talk about minutes of meetings, because obviously, minutes are quite important to record decisions that are made. And I got 7 tips here. A motion is essentially a question, and the minutes should contain the answer to the question. So sometimes owners, want less in the minutes, and sometimes they want, the Declaration of Independence in there. And finding the balance can be hard. So we generally say, if the motion is to approve Bob's painting to paint the foyer, then the resolution should be that the Strata Committee or Owners Corporation approve Bob's painting, etc. So the question is, do you want to approve the painter? The answer is yes, we approved, or no, we didn't. We then sometimes add notes below the motion to sort of collect if it's a key decision being made or there's certain disclosures that have been made. It's good to make those notes in the minutes so it's nice and clear what actually happened at the meeting. Tip 2, I think it's best practice to have the strata manager put the agenda together and draft the minutes. So for strata committees, we do include a number of meetings in our agency agreement, depending on the size and functionality of your building. So typically we would suggest that you let them come. Obviously they've been trained on how to chair meetings, how to put the agenda together, draft the minutes. It's obviously best practice to have the strata manager chair the meeting so it's nice and independent, record the votes effectively. Our strata managers know how to obviously deal with difficult disputes, how to, how to minute things, how to take votes, if there's, a deadlock, what to do, all that sort of stuff. They're trained and licensed to do that. Tip 4, if it's not part of the decision or motion, it probably doesn't belong in the minutes. So some people say, Jill from Unit 3 said blah, 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 and that's not in the minutes. Well, did it relate to the decision being made? If it didn't, generally speaking, it doesn't need to be in the minutes because, again, the minutes are on public record. You want them nice and tidy. You want them showing, obviously, the question or decision that was asked and the result of that. Minutes should be transparent. Any conflicts of interest should be noted clearly. Tip 6, minutes should be easy to understand and clear to those who did or didn't attend the meeting. That's a very important one. So if somebody didn't attend the meeting, the minutes should be nice and easy for them to pick up and understand what happened at the meeting. And the last one, minutes are a permanent record of the Owners Corporation. Again, they should be professional. So avoiding scraps of paper scanned in and those sorts of things. Again, we've got templates. Our documents look nice and professional. And again, it's a record of your Owners Corporation. So last little slide before I know I'm 12 minutes over time, but I will just see if there's any quick Q&A questions that I can answer here. But there is a lot to consider being on a strata committee. We know what we're doing. Rely on us. We're here to help. If you've got any questions, specific to your building, feel free, obviously, to reach out to your strata manager. We're here to help you. I'll just have a quick look, as I said, at the Q&A and see if I can help here. All right. It says, what about the financial power of the Strata Committee? Is there a range for financial decisions can be allowed to the Strata Committee? Okay, that's a really good question, anonymous attendee. I'll answer that one. The limit basically relies on a couple of things. Firstly, the budget. So if you're a large scheme, as I said, you've got a budget, you can't spend any more than 10% of a line item unless you go back to a general meeting or you remove that. For non-large schemes, effectively, if there's money in the bank, the Strata Committee can effectively spend it unless there's a restriction made on them at the previous general meeting. So sometimes owners corporations at the AGM say we don't want the committee spending any more than 5,000 or 10,000. That's your monetary limit. If they haven't set a limit and there's money in the bank, generally speaking, you've got the budget there. Strata committees can authorise the expenditure. All right, so let me just have a look. Sorry, there's a number in here. Thank you so much for your questions. Sorry, I've just answered that one. Is there a limit on the dollar amount a committee can approve for non-legal expenditure? So I've just dealt with that one. All right, good question here. Does the 10% rule need to be reviewed at the AGM annually? No, it doesn't. So if the owners corporation pass that resolution, that can be the rule that they stick by moving forward. If they want to change it, again, they can just go to a general meeting and obviously change that decision if they wish. All right, and there's a few more here. All right, we've got a good one here. What's the best way to deal with committee members who insist on a number of quotes for small value quotes, e.g., under $1,000 or $1,500? This is a good one. So often we get requested to get quotes for smaller value items. I guess the best way to deal with that is probably two ways. Committee setting a dollar value and saying, look, we feel it's unreasonable at $1,000. Or $1,500 or whatever the case may be. The second way might be pick a bunch of contractors that your owners corporation or strata committee are happy with and trust. So if you use them for a number of years, rather than sometimes delaying the process by getting a second and third quote, for example, if you wanted a foyer wall repainted, it might be $1,200, and you've used the painter a few times in the past, you might engage them. Versus waiting potentially 6 to 8 weeks. Meanwhile, the graffiti is still on the common area or something like that. So, so there's sort of two answers to that one. Templates. So I've got one here by Linda. Templates, where can we find these? Not sure which templates you're referring to. Reach out to me. I can certainly help you. Templates for parking we have, and it's best, as I said, that your strata manager creates them for you and helps you with that. Templates for minutes and notices, etc. Tip here as well with meeting notices, if committees want particular items, you can speak to your manager and say, hey, can you please draft me a motion for these particular things? And your manager will definitely help you out and do that. We have a massive motion library here of templates that we can use and amend, obviously, to your needs and sort of go from there. We've got another one here. What process or mechanism is present for owners corporations to vote upon a matter? If an owners corporation want to override a strata committee, it would be at a general meeting. So any owner can request a motion to go on the agenda for the next general meeting. If there is a consortium of owners that disagree with the decision being made, a general meeting can be called by 25% of the owners drafting or signing a written requisition for a meeting to be held with obviously specific motions on the agenda. I think that possibly might be the amount of questions I can get to, as I know I'm sort of quarter of an hour over time. So I'll leave it there. Thank you very much for attending. Again, feel free to scan the QR code. You can report your bylaw breaches there. I think on the Zoom invite, my email is on there. So if you'd like to ask me any questions, fire away. I love a good question. I'm a strata nerd. I'll try my absolute best to help you out. Hopefully you've enjoyed the session this evening. Thank you again so much for supporting this initiative, and look out for the invite next quarter for the next topic. And I've got a couple of ideas that have come up on the question here. Thank you, Airbnb, and a couple of different things there. So I really appreciate you logging on. Thank you so much. Enjoy your evening. Thank you.